The Inland Empire Workers' Compensation Lawyer live stream and podcast is to provide general information to workers in California about their rights under workers' compensation law and employment law. So if you're a worker in California and you want to be helpful to yourself and to your fellow workers, subscribe to our channel, hit the notification bell, and tune in for 10 or 15 minutes a week for a short discussion about your legal rights. This is episode number 5. The first of 2 episodes on temporary disability benefits under California workers' compensation law. Episode number 6, which will air next week, will cover how to calculate temporary disability benefits in California workers' compensation cases.
Temporary disability is broken up into 2 different types. Number 1 is temporary total disability, or TTD. That means that a doctor has certified you to be off of work, saying that you cannot work. You cannot perform your duties. Now, temporary partial disability is also known as wage loss, because if you are able to go back to work, then you could go back to your old job and work with restrictions, and you would be getting the same as you were before. However, if you're not able to do that, go back to your prior duties, they might put you in a different position, which if it pays less, you are covered by temporary partial disability. They'll go ahead and fill in the gap of what you should be getting paid. Or if it is part-time because they don't have that position full-time, once again, you'll be covered by that temporary partial disability, which is your wage loss of what you would have gotten if they could have accommodated you.
Now, a big issue that a lot of people run into, or injured workers run into, is that the restrictions aren't really reflective of their true limitations. So they go back to the employer, they give the restrictions over, and then they start doing a job and they start experiencing pain. In those circumstances, it's really important to communicate with the doctor as to what restrictions are going to be on that medical report.
One thing you want to do, as you pointed out, Alex, is you want to talk to your doctor and be very clear about what those restrictions are. Once the doctor gives you those restrictions and you feel comfortable with those, then you might get accommodated at work. And if you do get accommodated at work, then they should follow those restrictions. They can't be making you do things that fall within that scope of those restrictions, because then they're violating the restrictions, right, and you shouldn't be working. So let's talk about what happens if they do violate those restrictions. Or even if they're working within those restrictions, but you feel you can't do the job. What I would do immediately is, if you do know your restrictions, you got sent back to work with those restrictions, the company is adhering to those restrictions, let's talk about that scenario first, but you're still feeling a lot of pain. I would go immediately to a supervisor and a manager and say, listen, you guys are working within my restrictions. I completely understand that. However, I can't handle the pain. Please send me to a doctor, or please let me go see my doctor. If you already have a doctor chosen, a primary treating physician, the ones that gave you the restrictions, I need to go see them immediately, because I feel that if I keep on working, even with these restrictions, I will further injure myself. Now, if you have a problem or they don't want to do that for you, immediately call us and we'll take care of that situation.
A lot of people don't want to approach their employer and get into this kind of fuss with the employer over the restrictions, because they feel that their employer is just not going to listen to them anyways. It's important that you follow what my colleague George Ibuado said and step up and say to the employer, hey, this is what's actually going on. This is what I need. Because the judge at the Workers' Compensation Appeals Board, even if you have a lawyer, the lawyer has to go see a judge about the situation, and the judge is going to have required, before they'll even hear the case, before they'll even hear the expedited hearing, they want to know that the injured worker went to the employer and has some testimony to give as to what the employer did for them. If the injured worker doesn't go and speak up and just wants to go get a lawyer and hopefully the lawyer will help me, no, you're going to have to go and speak up about these issues. It's general information. It's not legal advice. That's what the Inland Empire Workers' Compensation Lawyer live stream and podcast is: general information, not legal advice. If you want legal advice, you need to contact a lawyer by dialing 844-984-8414. And after we hear the specifics of your situation, then we can counsel you as to what to do. But generally speaking, as George has pointed out, you need to stand up for yourself, because the lawyer can't do certain things for you. A lot of types of law, you have some wrong that occurs to you, You go get a lawyer after the fact. Workers' compensation lawyers work with you within a claims context that's ongoing. So it's a special type of relationship that workers' compensation lawyers have with their clients. So when you're looking for a workers' compensation lawyer, you're really looking for someone who can not only represent you at the Workers' Compensation Appeals Board, you're also looking for a counselor who can help you do things within the claim so that you can prove your case and have the best outcome.
I was going to give the second scenario.
Yes.
Second scenario is you have those restrictions, and they're not abiding immediately by those restrictions. We talked about it a little bit in the first scenario, but let's say the doctor told you something. It's said in the report exactly what the doctor told you. Those are the restrictions. Now you go to work and they immediately don't adhere to those restrictions. Give us a call quickly. Once again, speak up. Let your employer know and say, hey, here's my paperwork. Here's what the doctor said. These duties that you're making me do not fall within the scope of those restrictions. Please let me know how we're going to remedy the situation. But if you don't speak up and talk to us, or speak up and talk to the employer, a manager, a supervisor, then you're going to end up working with restrictions, those restrictions being violated and getting hurt even worse. And that's not what we want. We ultimately want you to get better. Now, I'm going to drop a little pearl of wisdom. This applies to a lot of things, not just this topic, but I'm going to be very clear, and then I'll give a follow-up to this advice. Number one, always memorialize your communications with your employer or anyone else that you have your ongoing claim with. So a supervisor, manager, employer, if you do go ahead and tell them, I can't work with these restrictions, I'm getting hurt, I'm getting more injured, please do that through email, a text, or a letter, whatever the case might be, but make sure that those are documented, because what could happen is the employer could turn around and say, you never told me. If you have those letters, those emails, those texts, I mean, it's really easy to provide those to the defense attorney or to the adjuster and say, hey, this is what the employer said. Now, they're not going to want to go to trial because they know that the evidence is there. So always memorialize through text, through email, through letter, what you've been speaking to your employer about. Now, a caveat to that is, because you are putting that on paper and it's a paper trail, please be very careful about what you say. You don't want to be rude. You don't want to say things that you don't want coming back up. So just say simple. Mr. Employer, Mr. Supervisor, Mr. Manager, I have these restrictions. I feel like I can't do my work with those restrictions because I'm in too much pain. That's it. Or Mr. Manager, Supervisor, Employer, I have these restrictions. I've been made to do these duties. I don't think those fall within those restrictions, and that's it. Those are good ways to make sure that you have evidence if you need it in the future, putting that on paper, text, or email. One thing I did want to point out about temporary disability benefits is that they're not taxed, just like permanent disability isn't taxed. What they do is they take a gross amount, your average weekly wage, and they base your temporary disability payment on that. They take the average of all your earnings and they divide that by the year. It's a complicated formula that we're going to actually talk about on our second episode about TD benefits. But once they reach a number, they pay you 66.66% of that. So if you're making $1,000 a week, you'd be getting $666 with 66 cents.
If you're an injured worker, you're going to definitely want to check out the contents of our channel, surf through the different episodes that we have, find the topics that you want to learn more about, listen to the discussions, and if you have questions, give us a call. The information we have is general in nature only. It's meant to help you, but it's not legal advice.